So welcome everyone who's here to this session on privacy breaches. How worried should you be? My name's Melanie Olynyk and I'm a partner in Maddocks Public Law Group. So I advise government on a range of issues, governance related, but my particular passion is information law. So FOI is part of that, but increasingly more and more each day it's this area of privacy. So how worried should we be? Let me say this, within the first hour of our invitation going out to today's session, we had 95 people registered. So that's a bit of a record for me, I must say. And then within the week, we had over 330 people registered. And now we were sitting at about 370. So I think that tells us a lot of people are worried about privacy at the moment and privacy breaches in particular. As to how worried you should be, well, I think there's always going to be some level of worry on these sorts of matters because a lot of the time they are out of our control. But hopefully today's session will give you some strategies and things to be thinking about to help you put things in place to try and minimise any risks that are there. Before I get too much further, I would just like to begin by acknowledging the traditional owners of the lands on which we're meeting today, all of us online, and pay our respects to the elders past, present and emerging. In terms of some housekeeping for today, because there is going to be quite a large number of people, I think we're up to about 137 at the moment and counting, what I'll get you to do is if you have got questions, we'll put them into the chat function. We'll see how we go. I'm not sure whether we'll have time to get through all of them. It might depend on how many there are, but by all means, pop in comments or questions into the chat function and I'll leave some time at the end to deal with questions. And if it's a matter where we haven't got enough time to get through everything, then what I'll do is we'll think of some ways that we might be able to give you some follow-up after today's session. And I think you'll have all been put on mute as you join. That just really helps with the sound quality. So we'd ask if you stay on mute and we will definitely be sending you a copy of the presentation afterwards. All right, well, this is what we're going to cover today. I thought I'd start off talking a little bit about data, information, and just what are the key privacy risks that we're seeing. So not only what I see in my practice, but also what the regulators are telling us about the key privacy risks that are out there. And then what we're going to look at is ways and strategies that we can use to manage those risks. I also wanted to touch on that situation of what do you do if a privacy breach happens to you, because unfortunately it's not really a matter of if, it's a matter of when. So making sure we are ready with our response if we are in the unfortunate position of having a privacy breach occur. And I thought we'd also should touch on some of the changes that are happening in privacy at the moment and an important reminder to keep on top of those changes as we go. So we're up to about 168 or so of us now. There might be more people who join us, but I think I'll get going into the session. So as I noted on the invitation, data being the new oil of the 21st century. And if that's the case, then people will be motivated to find it, mine it, and refine it. So I think we all acknowledge that data is a very valuable resource and it's used by governments as much as any other organisations to understand our customers and to make better decisions. And what's also pretty clear is it is a growing resource. There was some predictions for next year that the big data and analytics market will be worth $103 billion. And I think what we can see is, and particularly from some of these recent high-profile data breaches, is that data is being looked and searched for by those who want fortune and power. They want to get their hands on people's data. So unfortunately, with the Medibank data breach, we've been told that it is Russia behind that one. So in a way, it's some comfort to know that the AFP are onto them, are onto the people responsible. But I think equally, it's not that comforting to know that they are on our radar, but we still can't do anything to actually stop it. So this is the climate in which we're now operating. And unfortunately, this is true. Someone out there, if it happens to you, someone's going to be blamed for the breach. And I think we're starting to see, and have for some time now, that privacy, it's not just a data room issue. It's not just for the IT guys to worry about. It's now into the boardroom. It's into the highest levels of government and organisations. And we're having a discussion around risk, not just compliance. And we're talking about resilience of our services, not just delivery. So it's not good enough to blame the guys in IT anymore. It's everyone's responsibility. And I've got a little quick quiz here for everyone to get us in the mood. How much information do you think is required to mathematically capture the unique features of your face? So I've got up here a few options. I've got from the very big, but quite a lot of data, an entire computer hard drive, right down to a single sentence. So I don't know if anyone's brave enough to pop in the chat. What do you think? Is it a lot of data needed to capture the unique features of your face, or is it something that's only quite small? Oh, we've got a few guesses coming in. Excellent. Oh, it's varying. Yep. So I think there's a few up there with the big, and there's one or two brave souls saying it's only a single sentence. So very interesting. The answer, I'm told, is a single sentence, number 4. Deep Face, which is Facebook's facial recognition system, is nearly as good as recognising a human face as we are. That's a bit frightening. So that program only takes 256 bits to hold all of the characteristics of a unique face. And for that particular size, it says, let's say we got a thumb drive, we could have 1 billion faces put onto that thumb drive. Another disturbing fact I came across was, and this was a study done over 20 years ago now, from 2020, and it found that 87% of the population could be identified using a combination of gender, birth date, and postcode. And that's 87% of the US population. So data, information, it's out there, it's growing, it's valuable. And we have these privacy laws that are there to regulate the way that organisations hold and store this data. There are the 3 main privacy laws that I've put up here, which are relevant to all of you attending today. So we've got the Commonwealth Privacy Act, which regulates both personal information and specifically health information, and that applies generally to the Commonwealth's government agencies and the private sector. That's a scheme that has a mandatory data breach notification scheme in it. It can be relevant to all of us today. It can be relevant if we're holding tax file numbers and there's a breach with respect to those tax file numbers. And the regulator at that Commonwealth level is the Office of the Australian Information Commissioner. And then we have our other laws that we're more familiar with, which is the Victorian Privacy and Data Protection Act, which applies specifically to personal information and regulates the public sector in Victoria. Currently, no mandatory data reporting breach scheme in place. It does have an incident notification scheme through the regulator, so that's OVIC, but that is different to that mandatory data breach notification scheme. And then we've got legislation that deals specifically with health information. And in Victoria, that's both public and private health service providers or others that hold health information. And again, currently no mandatory data breach notification scheme in place. And that regulator is the Health Complaints Commissioner. All 3 of these laws place obligations on agencies and organisations to protect the personal information that it holds and protect it from misuse, loss and unauthorised disclosure. The threshold question we do need to think about, though, is what is the information that's governed by these laws? What in particular is personal information? And it's good to pause and think about that in terms of what you hold from time to time as well, and thinking about personal information being about an individual who's identifiable, or who their identity is reasonably ascertainable. So we know it's the information about Dan Andrews, or we know it's information about the Victorian Premier. Either way, it's personal information. It's not always quite that simple, though. I've got up here this little comment. What's your address? Oh, it's giving us some numbers. I mean, your actual address. There's another string of numbers. So I think it's important for everyone to have a think really carefully about what is the personal information that your agency holds. And as this slide shows, IP addresses, that's the question. Are they personal information or not? There was a recent VCAT case that looked at this, and the member actually found that an IP address on the facts of that case was not personal information about the individual. So that case is GMW and Victoria Legal Aid from this year, 2022. And member Smith found that the IP address recorded by a chat service was information about the ISP or possibly the device, but it wasn't about that individual. And that's interesting because we're finding in the Commonwealth space, and particularly one of the recommendations out of the Privacy Act discussion paper at the federal level, was that this definition of personal information be looked at and actually be amended and updated to clarify that it can capture technical data like IP addresses, device identifiers, and so forth. So I think this is an area for us to keep our eye on, see what changes there may be, but also thinking about what is the information that you hold in your agency. We're focusing here today on data security because we're thinking about data breaches. So we've got our information privacy principle number 4. So certain government bodies are also subject to Part 4 of the Privacy and Data Protection Act, which has those protective data security standards. And this is where there are additional obligations placed in relation to how we store our data. And as I mentioned with the OVIC, they have that information security incident notification scheme so that they can find out what's happening to information, where are there situations where there might be incidents that have occurred. And when we think security, I'd get you to think of it in a number of ways. So there's physical security, that could be anything from who's coming into your building, who has access rights to go into certain areas, where are your records physically stored while they're on your premises. Then you can think about it in terms of computer security. So we've got security measures we can implement like passwords or access restrictions to online databases. And also think about security in terms of the communication process. So are you using and sending information out by email or by mail, or how are you communicating your information? And I've got up here an example just from a 2-month snapshot from this year, which is examples of the sorts of organisations that have had a privacy data breach. And I think the interesting thing is it's a wide range of organisations. It's not just small ones, it's big ones too. It's Microsoft. You think, if anyone, they're going to be on top of data security. It's community organisations, it can be government. It really, no one is immune from these sorts of data breaches. And in terms of our key risks, the Australian Information Commissioner publishes information around data breaches and the causes of data breaches. And this, I must say, has remained pretty consistent over the years, that we are looking at around 63% from malicious attacks and around 33% by human error. And the remaining few percent are considered to be system faults. So 63% malicious attacks, that's pretty high, but even the number for human error at 33%. And generally speaking, when we're talking human error, we're talking about sending an email to the wrong person, or even mailing out information to the wrong person. Another insight from Olynyk that we see is 65% of data breaches affect 100 or fewer people. So they don't have to necessarily be massive breaches affecting hundreds of thousands. They can still be significant though. And here's some more data for you, this time from the Australian Cyber Security Centre. And they lead the Australian government's cyber security activities. And they also report an increase in number and sophistication of cyber threats, particularly through the use of ransomware. So they reported in 1 year over 76,000 cybercrime reports, which was an increase. And that translates to 1 report every 7 minutes. So even while we're online today, there's going to be a number of cybersecurity incidents taking place. And in their report, they note how foreign governments and military organisations are often behind them. In terms of the report, they also talk about the government sector and how they're affected, and it seems that the Commonwealth government was the most affected, followed by state, local and territory governments. And health sector, the education sector were 2 other key areas that were subject to these incidents. And their advice for everyone is implement the essential 8 cybersecurity strategies. So if you don't know what they are, after today, go away and find out more about them. But they're things like application controls, patch applications, configuring macro settings in Microsoft, things like this, backups. We need to be knowing what those are and implementing them for our organisation. I think the other interesting thing about this report that came out was they gave a bit of a case study around Qantas and said, look, we've been working with Qantas for a long time now and we're very proactive. We share knowledge, we participate in exercises together. And the sense I got was, being proactive is really essential in this space these days. Don't sit back and wait for things to happen. Go out there and find out and do as much as you can. Some more insights, this time from Olynyk. So there is no mandatory data breach notification scheme, as I mentioned, but there is this incident reporting framework that Olynyk has established. And it reports on that. And in its last report, it talked about an increase in notifications from Department of Justice, Community Safety and the TAC. But it said, that's not a bad thing necessarily. That was because they went away and actually looked at this really closely and set up regular monthly incident reporting procedures to make sure that they knew when incidents were happening, and then making sure that there was that notification to Olynyk. So that proactive process of putting this on the monthly reporting agenda and looking at it is a good thing, even if in the early days it does mean that you become aware of more things. And just in terms of the privacy risks and the key things that I see when I'm talking to people, I would put human error up there on, up my list right on the top. And it is usually email, or it's mail. I do hear stories quite often of mail merges going wrong as well, so that the information goes to the wrong recipient. Devices being lost and stolen, that's pretty common that I hear about too. And it's not just small things like a USB, but it's also laptops that go missing. USBs in particular, I think, are that danger area because they can hold a whole lot of data in a very small device. Other ones that I hear about in my practice are these ones where employees have accessed information outside of their authority, or perhaps disclosed it outside of their authority. And there are also issues around how long information is kept or it not being disposed of correctly. And then, of course, there will be incidents where there is also that malicious activity. So that's the climate we're in. They're the risks that we're seeing and the breaches occurring. So really what we want to look at now is how do we manage those privacy risks? And here are some of the tips for you. Number one on the top of the list is this one I've mentioned. Know what information you hold. Know what type of personal information you hold. Know if you hold sensitive information, health information. If you haven't done it recently, do an audit of what information you hold, because it's only when you fully understand what you have that you can then be prepared for things that might occur. The next one, don't over-collect. This was the very first thought I had when I heard about that Optus data breach. I thought, why is Optus holding people's passports? Why have they collected that information? Even if they needed to see it perhaps to set up an account, maybe it was an identity verification process, why didn't they just cite the information, or if they did collect it, use it for that purpose and then destroy it? So thinking about not over collecting, or if you do have it, then not keeping it if you no longer need it. And I think back to us with government bodies, have a think about your the information that you've been collecting as part of the COVID-19 response. So for a long time there, we were asking employees, for example, or contractors or visitors to provide us with information about their immunisation status. As part of that process, sometimes documents were provided that had identifiers in them, unique health identifiers. We don't want to collect that type of information. Go back and have a look at your records. If you still hold unique identifiers, you should be destroying them very carefully. So even if there was a valid need to collect it at the time, always thinking about whether or not that remains the case. So having to have processes in place to revisit those sorts of things. Another way of thinking about the information you hold and maybe when it needs to be destroyed, one way might be to de-identify the information so that you don't need to lose all of it, but you are taking out the personal element of it. That can be a really useful strategy, although it does itself come with some risks. And this term of de-identification can have various meanings. I mean, in one sense, it's just simply deleting out a direct identifier. So I take out the name and I leave all of the other information under the record, but it's not linked to an identifiable individual. That's not necessarily enough to de-identify information. So we also need to be thinking about other information that could be used to re-identify. So when we're talking de-identification, we really want to get to a state where the person can no longer be reasonably identified from that information or other information that is available. So we have to think about indirect identifiers. We have to think about the environment in which that information may be existing in. And I think in terms of data that exists in an open forum, if it's publicly available, there is a risk that you'll never be able to properly de-identify it. Another key area, as I've mentioned, is this one around emails. A key privacy risk. It involves this human error. People know to take care, but these sorts of things still happen all the time. So this is an area where it's a privacy risk, and I think the way we manage it is through training to our staff to regularly be on about the need to take care with emails. There can be more things that you can do as well. So OVIC has put together an information sheet with some tips about emails in particular, and it's come up with some things like that auto resolve function. So when you start typing in someone's name, I'm sending an email to this person, it automatically fills in who it thinks you're going to be sending that email to. The suggestion is turn that off. Make sure you type in the name that you want it to go to, because in a busy world, it is very easy to do that, not check it carefully enough, and the email goes to the wrong person. Another way could be to have some delay rules that are set up. So maybe it's certain types of emails, maybe it's emails with attachments, but putting in place rules so that even after you've hit send, the email isn't actually sent for a period of time and can be recalled if you realise that there's been some form of error. And there's another process available called mail tips, which can help you check for errors and things as well. So if you're typing in something saying I'm attaching something, it gets you to check that you've got the right attachments. You know, with emails, the sorts of things I see all the time is who the email's been sent to, but also who's been copied into emails. So making sure you carefully check everybody who's been copied in. And thinking about it in terms of an email that can sometimes have quite a long trail. So an email might start off being between a couple of people, and then it builds and builds and more people are copied in. Needing to go back and look at the very beginning of an email trail to make sure that the people now receiving it are appropriate to receive all of that information. Better is don't have long email trails, start fresh emails and making sure each time they're being sent to the right people. And obviously taking care with attachments to emails as well. Some other things in terms of managing privacy risks, this idea of identity verification. So making sure that we are dealing with the people that we think we're dealing with. And that can be particularly challenging if it's over the telephone. And there can be balances there. How much information do you need to get from someone to be confident that you are dealing with the person that you think you are? So you don't want to necessarily over ask for information, over collect, but you do also need to make sure that you've got the person that you think you have. Another really helpful strategy for dealing with privacy risks is this concept of a PIA, a privacy impact assessment. So these are tools where we want them to be done at the start of a project, or when we're looking at perhaps having a change in the way that we deal with information. And what these assessments do is they make us stop, pause and think about what information's involved and why are we doing what we're wanting to do. So it makes us have a think about what is the information that's involved in this particular project or item. What sort of personal information? What sort of health information, for example? And then it makes us go through a process of saying, well, why are we collecting it? What's our purpose? Why do we need it? And how are we going to use it? What's the point of getting it? How do we use it? And then how are we going to be disclosing it? We need to think about that up front. Who else might get this information? And if we do that, it then takes us through an assessment where we then think, well, are there any risks with us doing all of this? Are we actually allowed to use it in that way? Or can we give it to these other people that we want to? And it may well throw up issues like you can do it, but only if you've first given notice that that's what you need to do. Or you can do it, but you need a framework around how you're going to do that. So some sort of MOU or protocol that's in place. So PIAs are really useful. They're designed to look at privacy risks and work out how significant the risk is and whether that risk can be mitigated in an appropriate way. You've got to do them at the start of projects, not at the end, because it's too late by the end. You're sort of chasing your tail by then. So the challenge for us often is, how do we make sure people think of these at the right time? So do we have something in our procurement policies that talk about if you're procuring a new software system, you need to be doing a PIA first that looks at any potential privacy issues with that. So another example might be if we're looking to move where we store our data. If we're going from a server that we've had on site to moving it to the cloud, do a PIA before we make that decision to make that change. And PIAs can be really useful tools even on small things as well. So they don't have to just be the big IT project. It might be simply a different way that you're now going to be corresponding with customers, or the sorts of information that you might be collecting. I think in the Commonwealth sector, they do PIAs really, really well these days. It's been ingrained into them for a very long time. It's a requirement under their codes for public servants. So they know about privacy impact assessments and how they can be useful. I think we're still learning in Victoria how to do a good PIA and to make sure that they are done. Another strategy for dealing with privacy risks is this one of training, staff training. So making sure we do it on induction when someone joins, but not forgetting about it after that, making it regular. So using events like Privacy Awareness Week that comes up each year, using emails, intranet as generating interest in privacy matters. And in the message that we give to staff when we're giving the training, it's simple, practical things that they can relate to. Don't look up information that doesn't relate to what you need to do for your work. If there is someone coming into the building and you don't recognise them and you can't see them with a name tag or a pass, maybe that's the point at which you ask some questions. Covering off things like, if you're holding documents and they've got this personal information in them, are you allowed to actually take them out of the workplace? What sort of permission might you need? If you're going to be doing it, how are you going to be doing it? If you're putting information on a USB, how are you doing that? Are you password protecting it? And the other key information that we want to convey to staff is the need for them to realise that if something does get lost or stolen or something happens or they're not quite sure, they need to report it immediately. So this idea of them getting in touch with the privacy officer or someone in the organisation so that someone else knows that there is an issue and that it needs to be looked at. So often in the training I give, if it's one message only that you take away, it's if anything happens or you think there might be a privacy issue, call your privacy officer and then make sure someone else can look at it. Again, in terms of managing privacy risks, one thing I think we need to be thinking about carefully is contractors. It amazes me, whenever we hear about a data breach in the media and a data breach affecting government, a government agency, there's a lot of attention given to that. It's the fault of the government, should have done better. But often when you look a bit closer at it, it's not the government body that had the breach, it's its contractor. The contractor won't necessarily get named, it'll be the government agency. So I think these days government agencies are aware that they can pass on legal liability for breaches to their contractors, and they can do that by having a privacy clause in their contract that does that and makes sure the contractor bears that legal liability for a privacy breach. But that's not enough anymore, because it's not always just the legal liability that's the issue, it's the reputational one as well. So number one, make sure you have a privacy clause in your contracts, but what I think you need to do is more than that these days. When you're looking at contractors, you need to be looking at their health check in terms of privacy. What's their privacy profile? What can they tell you about, whether they've had any breaches, what their responses to those were? And in clauses these days, making sure that we are all clear up front what is going to happen if there is a breach. So we don't necessarily just want the contractor going off and doing their own thing. It is a reputation issue for us as well. We want to know about what that issue is, and we want probably some input into what happens in response. So going away, thinking again about your contracts, making sure that the clauses in there are, are up to scratch, but also thinking about that due diligence that you undertake on your contractors as well. And I think particularly important when we're in high risk areas where there's children involved, there's health information, if it's tax file number information. And we've got some tips given to us from other agencies. So here are the tips that they give to individuals. It's important that they are updating their devices, getting the multi-factor authentication, regularly backing up, using passwords, and watching out, being vigilant for scams. And you can again emphasize this in your own staff training, or you can do exercises where you send emails as a check to see if people are clicking on links they shouldn't be clicking on. And for organisations, these are the sorts of tips they're coming out for us. This issue of remote workers and making sure we review that cyber security posture for those. If there are vulnerabilities, that they're patched within 48 hours, that we're only looking to use reputable providers. Sign up to be a partner with them, take that proactive step, find out information from them. And in particular, testing what you do. So test your own cybersecurity detection, incident reporting, business continuity and disaster recovery plans. Don't just have them, test them to see if they're effective at managing that risk as well. And the other thing that they recommend organisations do is report all cybersecurity incidents to them, and they can provide help and assistance to you if that's the case. All right, so that's the risks that we're faced with and some tips for you to manage those risks. Then we're in the stage of what do we do if there is a privacy breach? So this slide really is a snapshot of the key things. And as I say, in the training I give to staff, number one, tell the privacy officer. If that's the only message you remember, then that's something, making sure someone else realizes that something has happened. Even as bad as you feel, if you've lost your phone, your laptop, you'll feel terrible, but don't end there. Make sure someone else knows and that they can do something about it. Because the main thing with privacy breaches is working out what can we do to prevent harm. And that's really the goal whenever we have a privacy breach, trying to work out as quick as we can, what's the harm and how do I minimize that harm? So the same time as telling the privacy officer, I'm thinking about, well, if it's the email that was sent with the wrong people or the wrong attachments, can we recall it? Can I recover the information? Is it a situation where I realise I've been giving access to information that should have been restricted? Well, do I immediately then shut down that system? Do I restrict the access codes? And there've been examples of this, where there's been websites found where they've had this information available. So shutting it down, changing restrictions. We're focused on trying to minimise potential harm to those that have been affected. And there are 4 key steps that we take. So you've probably all heard about these. It's this idea of contain the breach. Then we have to go and assess the risks. The next step is we have to think about, do we need to notify? And even if we're not subject to a scheme that says we must, we still need to be thinking about, should we be notifying? And then the last one is more of a reflection. How do we prevent this from happening again, or could we have done things better the next time? And I think you can judge for yourself how you think some of the big data breaches, how their organisations have gone on these 4 steps. I mean, what did you think about Optus's response? Did you think it was quick enough? Did you think they gave enough information to people? Same with the Medibank. You know, that was one where there was information being given, but in drips. You know, is that, from a consumer perspective, was that adequate in your mind? Was it too little information too late? So you're going to be judged by your response to the breach, more so than just the breach having occurred. And how you respond is always case by case, but your speed and your adequacy are the two key things that you're going to be judged on. And they can have big implications, not just financial implications, reputational ones as well. All right, so let's a bit of a deeper dive into these 4 steps. Step 1, contain the breach. So we need to work out what's happened. So this is a fact-finding exercise. Okay, well, how did we find out about this? Who found that out, and when did they find it out? And then, what do we think has caused it? Are we able to find out the cause? So as much fact-finding around what has happened so that you're aware of the situation. What is the information that we're talking about? And again, we saw with the Medibank experience that they didn't know all of this at the start, and it was a process of them finding out as they went, but trying to find out as much as you can at that very start. And then we want to know what's happened, because we want to know the best way to contain it. So the examples of recovering the information. If it's a laptop that's gone missing, shut it down remotely. Hopefully it's had encryption and all sorts of things on it anyway, but what else can we do to make sure that no one else gets access to that information? So step 1, find out as much as you can what's happened and then contain. Step 2, it's the risk assessment. So we're now looking at, in that deeper dive, how many people are we talking about? What type of information are we talking about? What is the impact going to be to those individuals? And what's the impact to us as well? Thinking about that and doing that risk assessment. And that then leads into this 3rd step that we're doing all pretty quickly together is, well, do we tell people about what's happened? And at the moment in Victoria, there is no mandatory data breach notification scheme under the privacy principles, but it can be something that is good to do and can be part of your mitigation strategy as well. And again, the guiding considerations are, would that there be serious harm to people? And if I tell them, can they minimise that harm? So the classic example is, I know it's credit card details that have been compromised. I tell the people that so that they can cancel their credit cards. And that way, hopefully, they're not subject to fraud down the track. It could be in other situations where the laptop's been lost or stolen, but it was encrypted, it's been recovered, the data's all been shut down. So and we've been able to check no one's actually accessed any of that information remotely. So the risk of any harm is quite low. So that might be that no one needs to be notified about that, even though there might be some personal information. The other thing to be thinking about is not just the people affected, but whether we should be notifying anyone else as well. And that includes OVIC as the regulator, possibly Victoria Police if there are questions of theft, or it could be your insurer. Now, is it a matter where you should be notifying your insurer in case there are claims down the track? And then that step 4 then is around preventing future breaches. So we've done 1, 2, and 3 quickly in the heat of the moment. We might need to be going back, reassessing what is the breach, how do we contain it, do we now need to tell more people? We're continually doing those 3 steps. And then when we're out of the worst of it, we then say, do we need to do something differently for next time? So review what you did with the aim of preventing it from happening again, or perhaps increasing and improving your response to it next time. So again, is it the human error of the email? We get back onto the staff training. Is it that there wasn't a policy that dealt with this situation and we need to plug that gap? Is it the fact that the security measures weren't good enough and we need to improve those? Or do we need to go back and do an audit of what is the information that we're holding and why, and what are the controls around it? And that can include how long we keep data. So what I'd say is another way of managing your privacy risk is to have this robust data breach response plan. There are lots of templates out there that you can use. Make sure you've got one that you can go to, because you're not going to have a lot of time if the breach hits you, and you're going to have to know how to respond. So you should be developing your own template notification letters to use in case that is necessary. Have them there ready to go, and hopefully you don't need them, but they're there if you do. And that last one of test against your response plan as well. Test those to make sure they're as good as they can be. So I've got up here a checklist that you can ponder after today, but just to make sure we're thinking about the best way to manage our privacy risks. Are we doing all that we can? So knowing the information we hold and what our contractors hold. Are we really needing it? Do we still need it, or we don't need it anymore? Do people know what to do if there's a privacy breach? Are we doing privacy impact assessments? You know, do we have robust processes in our contracts, in our policies? Is it the case that perhaps we have underinvested in this and we need to look at that? Do we have senior champions in our organisation that are telling our staff that this is an important issue? And remember that essential 8. You know, do we know what that is, and how are we tracking against it? And then to finish off, before we have some questions, I can see a couple have popped up in the chat, so I'll have a look at that in a minute. But the last one I wanted to just touch on were, this is a changing space as well. So it's important for us to keep up to date with changes that might occur in this landscape. And at the Commonwealth level, we've got this bill that is seeking to increase the maximum penalties for serious and repeated privacy breaches. And this came in pretty quick after we had some pretty significant privacy breaches. So the penalty at the moment is $2.22 million, and they're looking to increase it to whatever is the greater of $50 million, or 3 times the value of the benefit obtained through the misuse of the information, or 30% of the company's turnover in the relevant period. So it's interesting. It's a bit like the competition and consumer laws, where they tie penalty to what you got out of it. So in that case, if you've been misusing your market power, you've been anti-competitive, but that's actually quite profitable for you, the laws say, well, no, we're going to penalise you so that you are not better off. And I think it's a similar sort of concept here. You know, $50 million, significant amounts. There's also been that long-standing review of the Privacy Act at the Commonwealth level, and so I think we're likely to see more changes in that space as well. So they might actually introduce a statutory requirement to do privacy impact assessments. So I think this is an area to keep watching. And just as another example, in New South Wales only recently, they have now introduced this mandatory data breach notification scheme. So in Victoria, it's looking, you know, more and more likely that that may well be something that happens to us as well in the near future. So I'll leave you with this thought. Better to be despised for too anxious apprehensions than ruined by too confident security. All right, well, I'm happy to take questions. So I'll have a look at the chat here now. Now, there was a question up here. Is an effective control measure for organisations to only gather the minimum data required for the transaction? So I think that one of the privacy principles is only collect what you need. So you do need to be thinking about what do I need? What's the minimum data that I need for that particular thing? Don't over collect. That's certainly a very big way of minimising privacy risk. I've got another one here. OVIC online reporting form requires responses to all of these issues, which is useful. So use the OVIC process. That will step you through these sorts of things. You know, what happened? What have you done about it? Who have you been telling? All of those things that you need to be thinking about in the response to a breach. Got another comment here. I think the concept of citing identity documents rather than holding on to everything is really something to think about. I think that's a big one. And you can think, you know, it could even be a council that has an application form to get a disabled parking permit. So there might need to be some sort of evidence of a disability or a medical condition, but does that need to be kept in the file? No. Yes, it needs to be cited as evidence for the reason why you're granting the permit, but you don't need to be holding on to that information. There's another one here. How do you navigate the tension between the PROV, so the Public Records Office retention requirements, and holding personal information for extended periods of time? So the privacy principles deal with this by saying there is an obligation on us to destroy information if no longer needed for the purpose that we hold it for. But that is subject to record requirements, record retention requirements. So we also need to be aware that under the Public Records Act, government bodies can't destroy information unless they are permitted. And you're permitted to destroy if the retention authority has expired. So in some cases, you might never be able to destroy a record, but in others, it will allow you to do it, and after a certain period of time. So it's really knowing what your retention requirements are by law and then working out your processes to make sure that they reflect that. So it could be quite clear. It could be you have to hold information in this sort of record for 2 years. So can you then set a system in place so that after 2 years, the system deletes it or it puts a trigger to say this information now needs to be assessed, whether it's appropriate for disposal. Sometimes it just talks about the administrative use being over. So again, how can you build in some processes to say, okay, after 12 months might be appropriate time to say if there's been no further action on that matter, then that's the time at which it can be closed off. Privacy does defer to other laws. So if there's a particular requirement that you must keep information for longer, then that will override privacy. I'm just going to look at the next one in the chat. So what's your view on notification to affected individuals where it only involves possible injury to feelings? Or what about a case where notification could indirectly, I think it's identify perhaps another individual? Notification is hard, it's tricky. I think you've got to be guided by the overarching is them knowing it, able to help them, because that's the idea. If there's potential for harm, what can they, knowing what's happened, can that actually help them reduce that harm? So like the credit card, I want to know, even if it's upsetting, because I want to be able to make sure that I cancel my card. Or if you've assigned me an identifier and that's gone out, I need to know that so I can take other measures. So the question, if it's only injury to feelings and there's nothing they can do about it, maybe the notification being distressing is a reason why you wouldn't notify. If there's nothing else that they can do to remove and minimise that harm, and it's only going to add to their stress and anxiety, that might be one where you don't notify. I think there's another, with identity, one option for Victorian agencies is to use a reusable identity via Service Victoria. It's then protected by Service Victoria, and we hash and one-way encrypt. I sometimes get asked about this, in terms of what are the best sort of tools to use. And I mean, generally, I would say, if there is a government service that provides this kind of function, you know, you can expect that they will have looked at all the privacy issues. They'll have done their very thorough privacy impact assessment. They will be thinking about security. That's their business. So if someone else can do that work for you, you know, use it. And it's similar with other services like the MyGov ID. You know, there will be processes that have already put in place to make sure that that information is appropriate and secure. All right, I think that's the end of my chat questions. Any others that anyone has? I'll just wait to see if any more pop up. What I did say was, though, we'll send everyone a copy of this presentation after today. And if you have got any feedback, that'd be great to see. Or if there are other topics or worries that you have, you know, feel free to reach out to us as well on that. There's my details. But you're not alone if you're worried. I'm hoping, though, that you're not all kept up at night also, and that we can't eliminate the risk, but there are things we can do to try and manage that risk as best we can. Trying to get buy-in from your organisation at the very senior levels, if you can, and adopting as many of these strategies as you can to manage that risk.